passes, or when probate is even a thing that needs to be dealt with, or what assets can avoid probate, or what assets might you never want to go through probate. So there's a lot of things that people don't really know about when it comes to dealing with someone's estate after someone's passed, especially with probate, and the types of tools that you use to either avoid it, to specifically go through probate, and then what that process really looks like. So it's a complicated process, and a lot of people haven't dealt with this before. So it's something that you're not expected to know how to do on your own. And certainly the internet is not a great source all the time for any sort of information with the law in general, but with probate in particular, there's a lot of bad advice out there. So it's just something to really try to educate yourself on. And that's what we're here to talk about today. So we do have a couple of really interesting topics coming up as well. We've got the next Wednesday, we're going to be talking about something you may have all heard of, the Secure Act, relating to retirement accounts and how those are dealt with when you're passing it on to your family members. And then the week after that, we have planning for farmers and what types of considerations they need to have when they're passing on their estate to loved ones. Because with farmers in particular, it tends to be a bit more of a sort of a, not more complex, but it's sort of a marriage between business planning and estate planning. So welcome, everybody. I'm attorney Justin Randall here with Hooper Law Office. Today, our topic, as I mentioned a moment ago, is we're going to be talking about probate today, and some of the things you're going to want to be aware of when you are dealing with a probate or are planning for your own estate, whether that's because you want to avoid probate like the plague, or because it's the process that you're planning on using for your plan. So for those of you, actually, before I get in too much, let me just go over some housekeeping items. You will be receiving some materials from us today. So if you are participating via Zoom, if you're pre-registered, we have a handy little what happens when you go through probate and what kind of happens when you're going outside of probate, and what types of assets pass through just by their own, by the terms of those assets, or sort of how they're owned. It's a little helpful flow chart. So if you pre-registered, you will be receiving that from us. Another little housekeeping item is if you pre-registered, there's a feedback evaluation form you'll be getting that is where you can let us know if you'd like us to reach out to you in any way to set up a initial consultation. That, if anything you heard today is concerning to you, that, for your own plan that you need to have looked at, or a loved one situation is concerning because of what we talk about today, yeah, absolutely fill that out, and we can reach out to you once you fill out your contact information there. Another thing on that form as well is, did you find the information today useful? Do you have anything you'd like us to talk about topic wise? We're always looking for additional topics to talk about. And is there anything process wise that you think could improve? We're always improving, so it's always good to hear back from you. But okay. So to get started, a question I get a lot is, well, what exactly is probate? What does that even mean? People are familiar with the term generally, having heard it many places, and generally not hearing good things about it, which may or may not be fair depending on the person's situation and the information, the source of that information. But probate is a process in which you deal with someone's estate after they've passed away. It's where the will becomes a very important factor, right? If you have terms in your will, the probate court is where those terms are dealt with, or probate is the process in which those terms are dealt with. So it does not always involve actually going to court. In fact, most of the time it doesn't. There are kind of two areas of probate. There's informal and formal. Informal probate, you're still, going through the court, you're still having them sign off on things and following their deadlines, but you're not, standing in front of a judge and listing off the assets or anything like that. formal or informal probate is what we deal with, I would say probably 95% of the time for people's estates. Formal probate tends to come up if there's more, more complex factors that you need a court to settle. If anybody is really, if there's any sort of dispute over anything, or, somebody is contesting a will, that's where that's generally going to occur. So probate, though, overall is the process in which somebody's estate is divided up and in which creditors are paid, if there are any, and if any sort of irregularities appear, how they're dealt with. Not all estates go through probate, though. It depends a lot on the type of estate plan you have and how you own your assets, and what beneficiary designations are on those assets as well. And if anything I raise is confusing or anything like that, and you'd like some follow-up questions, if you're participating via Zoom, we do have a Q&A function. You can ask me questions as we go along, and I'll see them pop up, so I'll try to get to them. But so a big misconception people have with probate, though, is that, if I have a will, I'm not going to go through probate. Well, unfortunately, that's not necessarily the case. If you have a will as your estate plan, so we're not talking about trusts here, but the will is your estate plan, then what you're really sort of signaling to everybody is that, hey, I am intending for my estate to go through probate, because wills only control assets and only direct assets that are actually going through that process. If an asset avoids probate, it also avoids the will. Now, some people will try to mirror the beneficiaries of the will percentage-wise, and individuals that you're leaving things to, or maybe charities that you're leaving things to. But if you really intend to use that will, you must have at least some part of your estate go through probate for it to actually direct anything at all. Just showing up to a bank with a will, but not having a probate ongoing, or having the proper documentation that you are able to act in that capacity, that's where, you run into issues, because having a will by itself doesn't do anything. So a question that just came in is, what if I have no assets, but I do have a will? So I guess there's a couple components to my answer on that question. If you don't really have any assets, so if an estate overall, if total assets that are a part of that estate and that are going through probate are under $50,000 total, not just per asset, but combined, you can use what's known as a transfer by affidavit, so that you transfer those assets directly to the beneficiaries. Essentially, under that amount, the court's determined it's not cost efficient for them to have a probate necessarily open to be followed. But if you have more creditors or more debt than you have net worth, right? If your net worth is negative, because you have what's called a deficit estate, you may still want to use probate as your process, and likely will. So just because you have a will, but not necessarily any assets that you own yourself, that's not necessarily a problem. A will is still a place in which you can designate who you want to be in charge of your estate as well. That's where you name what you might be familiar with as the term executor, but in Wisconsin, it's called a personal representative. So that's where you still have the option to name that individual and nominate that individual. And if you have minor children, you still want and have to name guardians for them in your will. That's the document in which you name your nomination for guardians for minor children. So it's not just assets that it deals with. It is a big component of what they deal with, but you might have other situations as part of your estate in which you're dealing with a probate still as a necessity. So yeah, under that $50,000, that transfer by affidavit is usually how assets are transferred, but there might be other reasons. So wills only directing the assets that go through probate, though, The biggest issue we see with that is somebody has a will as their plan, but then they avoid probate with all of their assets, or they have only a couple of the assets actually go through probate. And so what you'll see on that handout that you'll be receiving from us as well is sort of how that works. With beneficiary designations such as payable on death or transfer on death, POD, TOD is kind of how you'll see them listed. Those pay directly to those individuals or transfer directly to those individuals listed, or if it's a charity, directly to that charity that's listed. They do not go through somebody's estate. They avoid that probate process entirely. So what that essentially means, though, is that, if all of your assets are being left through beneficiary designations, or at least if most of them are, but you have these intricate planning measures in your will, or maybe you have provisions for, a trust for a minor child, or you have specific wishes of how that money is to be used, and you want that followed. Avoiding that probate process with beneficiary designations just essentially means you devalued your will. You have a very expensive piece of paper potentially that somebody put time and effort into making, but you also spent money on getting created for yourself. And if you're not going to use it, what good did that do you? So you want to make sure you're using whatever plan you have drafted for you. And if that's a will, and you want to be aware that what you're saying is, I am at least intending for a sizable chunk of my estate to go through probate, so that those terms are followed in my will. So, by having everything beneficiary designated, like I said, that does avoid probate with those assets. The biggest issue that we see generally come up in terms of just administrative problems when that happens is somebody who is the personal representative, for example. A lot of times, because homes don't generally, or real estate doesn't generally have a payable or transfer on death designation on it, generally speaking anyway, mostly when somebody avoids probate with all of their financial assets, it's just real estate that's going through probate. And that can be a huge headache for the personal representative to deal with, because what happens if everything is going outside of probate, therefore not under the control of the personal representative in terms of assets, money that they're able to pay expenses with, but there's ongoing expenses with the home. Well, there's no money in the probate estate. All of the beneficiaries have been paid directly. Those beneficiaries are under no obligation to give that money back to the personal representative or to the estate to pay those expenses. So it leaves them in a really awkward position. That personal representative is not generally going to ever be personally liable for those debts of the estate, right? I mean, it's not, you don't assume that debt by performing that role, but it still puts them in a really difficult position of either having to ask for money back from individuals, or if they're a beneficiary of the estate themselves, they will often use their share to do that. Again, not necessarily under any obligation to, but they will often do that anyway. And then there's no guarantee anyway that they'll be paid back by the estate or reimbursed if there are not enough assets to do so. So it puts them in an awkward position. So one of the questions that just came up is, if you put everything into a trust, will there still be a required probate? And again, that the answer to that as an attorney is it depends. But most of the time, as long as a trust is properly funded, and what I mean by that is, your assets are titled in the name of your trust during your lifetime, or are beneficiary designated to that trust to pass into it after you've passed away, as long as that covers everything that you have, and anything that potentially remains outside of the trust that would otherwise go through probate is under that $50,000 amount, then no probate should be required there. What can happen with trusts a lot of times is people don't properly fund them. And that's when you may still need to use probate as a way to get the assets back to the trust. So usually if you have a trust, you also still have a will. That's how it should be done anyway. I won't say always, because you never know what somebody's done out there either. But, whenever we draft a trust, we are drafting what we call a pour over will. It's called a pour over will because it essentially pours the assets back into the trust if something is left out. Now, ideally you would never want that to happen because, as I mentioned earlier, with a wills only control what go through probate. So if you're using a pour over will to get things back to the trust, that means you ended up in probate, which it does kind of defeat the purpose of the trust. An alternative to a will that people often use when they're specifically trying to avoid probate is, I'm going to set up what's commonly called a revocable living trust. So that's an option as well. So if it's properly funded, short answer, if it's properly funded, no, it does not need to go through probate. If there's things that get out of alignment with the trust funding over time, which does happen, it might. But we also use other tools as backup plans as well to still hopefully avoid probate in those situations. Okay, so I have another question here. Are children responsible to pay off any bills accrued by a parent that has passed? So the only time that would really come up is if you were like a co-signer on something, or you had signed a personal guarantee of something along with a parent. It could be that you're responsible to some level for that. But if a parent passes away, the debt is all theirs or is their estate's, then no child is responsible to pay off their parents' debt unless they themselves personally guaranteed something. So yeah, there's no concern for you there. That can't be passed on to somebody. That's not, once we're all adults, it's not our fault, what our parents do, or it's not a parent's fault what a child does, right? Once everyone's a legal adult and signing their own, loans and things like that, that's their responsibility. Now, a benefit though to probate when somebody has a lot of creditors is it sort of functions like a bankruptcy, essentially, a bankruptcy after someone's passed, where if there's not enough in the estate to pay all of these creditors off, they can take what they're owed to the extent that they can into, loan priority and all of that sort of designation of secured loans versus unsecured loans that you might see in a bankruptcy court. But if there's not enough money, they can't come after the kids necessarily. They can't, come after, other family members or the personal representative personally. So you don't have to worry about that as long as you did not personally sign on to that loan as well as like a co-signer. The one thing I'll add to that though is the personal representative is responsible to act in a fiduciary capacity, right? They still have to do the right thing. So if there are a lot of creditors out there, you still have to make notice to those creditors. That doesn't mean you're going to be personally responsible as the personal representative, but you also can't say, well, I still want my inheritance if you're a beneficiary, and say, but I know all the creditors are going to eat it up, so I'm just not going to notify them. That's not okay. You can't do that. That would be a huge problem. So, that's the one caveat to that I'll add, but no, you're never personally responsible for it otherwise. Okay, so, like I mentioned, though, things avoiding probate can be an issue if that's the main point of your plan, right? Now, there are also some things, though, that you just don't want to go through probate, that you might want to mirror the designations through the will, but to still use, payable on death or transfer on death designations. Specifically, things like qualified retirement accounts and occasionally, tax deferred annuities, because a lot of times, when those assets go to the probate estate, or if, the beneficiary on somebody's account says my estate or the estate of, it can force a quicker, shorter payout period of that account, which then expedites the taxes being paid on it. So under the new Secure Act rules, which I'm actually going to be talking about next week as well. So if this interests you at all, tune in next week too. Under the new rules, most people have, most children of parents, for example, have a maximum of 10 years to take the entire retirement account out. Spouses still can roll it over into their own and get a lifetime stretch, but and a few other very specific exceptions can get have an exception to that 10-year payout, but most people are going to have a maximum of 10 years to take it out. But in order to get that 10 years, you have to be a designated beneficiary under the terms of the IRS code, which in a state is not necessarily. So it can force a 5-year payout, which is half the amount of time of the 10 years, obviously, and therefore basically double the rate of the tax payment. So you never want to leave somebody's IRA to the estate of. It happens. I've seen it happen. Not something I set up, certainly, but I have seen it happen or heard of people's kind of horror stories of this happening where they had to expedite the taxes. So just because you have a will doesn't mean you actually also want everything to go through probate. You might want to coordinate those beneficiary designations with the beneficiaries if it's an asset that it would cause harm for it to go through probate. But things like bank accounts, life insurance policies, real estate, traditional investments, things like that, those potentially you do want to go through probate if you have a will. As somebody brought up, avoidance of probate can be a big concern for people. It's such a concern that some people, which document they use as their estate plan is, driven mainly by that desire to avoid probate. So, I mentioned earlier, if you have a trust, trusts are not subject to the probate process. They have their own terms, like a will would, of what happens after somebody passes away. It's still a central document that you have, just like a will that coordinates all of the assets, but they don't go through probate as long as they're properly funded. So a trust in this case is a lot like a will in that, if you have a will, you're saying I'm using probate for at least some or most of my assets. So you want some things to go through probate. A will without anything going through probate is pretty useless for the most part, unless you have some of those other situations like minor children, things like that. But a trust is also worthless if it's completely unfunded and nothing is ever designated to it either. These are plans that if you have put in place, you want to actually use. But probate is something that people often have heard bad things about, and mostly that's it kind of stems from how long it tends to take and how complex the process tends to be. An average time frame, and there's no real set time frame that you're going to see. It's going to range depending on the complexity and if there's any sort of delays of any kind. But an average time frame is roughly a year or more to a year and a half, roughly. If you get it done quicker than that, that would be the fastest probate I've ever seen. I suppose it can happen if it's a relatively straightforward estate, but generally it's not that quick. Another issue that people run into with probate is as somebody's personal representative, your authority is not immediate, right? As I mentioned, you just showing up to a bank with the will saying, hey, look, I'm the personal representative. That bank is under no obligation to listen to you at that point. Before you can begin acting as a personal representative, you have to first submit the will to probate and then be approved as personal representative. After you've been approved by the court, if there's no objections or, people, saying that you're not fit to act in that role, for example, then you get what's called a domiciliary letter from the court. And that acts as your documented proof that you can act in that personal representative capacity and unfreeze the bank accounts and start, paying creditors and things like that. But not until that happens can you do that. So it not only does probate in general tend to take a longer period of time than, if somebody had a trust as their plan, it also is delayed a little bit in that authority to begin acting. It's not a long delay necessarily. It's, maybe a couple weeks generally, but it's not immediate. And a big concern comes up when people realize that, as I'm, mom or dad's power of attorney for finance, and they go into the bank after they've passed with that capacity and say, well, look, I was the power of attorney for finance. When they don't realize, when people don't often realize that powers of attorney end at death. So just because you were in that capacity does not mean it continues on after a parent has passed. So that's where that gap in authority can kind of come up, where even if you were the financial power of attorney agent and the personal representative, that transition is not immediate. You still have to be approved. And, again, like I said, it's not usually all that long. If your family situation is very complex and people are going to have a lot of issues with who's being named, it could take a while. But hopefully that can be avoided in advance with proper planning or with family discussions or anything like that. I mean, there's a lot that can be done to avoid conflict in advance. So that's one aspect that kind of people are a little concerned about. Another is, like I said, the overall length of time, but also the cost of probate. Again, there's no set number on this because it's going to depend on the size of the estate, the complexity of the estate, how the attorney's office charges, and the court filing fees and all of that. But an average cost you see for probate is usually around 3% or so. So it can be expensive depending on the size of the estate. For example, if you had $1 million going through probate, that'd be a $30,000 probate based off of that 3%. So that's not a set number, but that's kind of the average of what you would tend to see, I think, overall. So it can be expensive, right? And that's, potentially more expensive than it needs to be because trust administration tends to be less expensive for people overall. And partially that's because probate, it tends to be a lot more work on the attorney's end as well. So because of the attorney's fees and the amount that they're of work that they're putting into it, it's more expensive generally than administering a trust, which tends to be a lot more straightforward for an attorney to deal with. I won't say all attorneys that's the case, because potentially if they have no experience administering a trust, it's going to be just as complicated for them there. But for our office, for example, an average trust administration is probably between 6 months to a year. So it's still not immediate, but you can cut out 6 months there. So those are kind of the horror stories that you'll hear about probate. But I sort of alluded to this earlier as well, that there are reasons you do want to go through probate. And actually, before I get to that, I have another question here. Can anyone challenge a will after someone passes? Yes, yeah, they can. So it has to be for very specific reasons, right? They can't challenge it just because they're unhappy with it or they're unhappy with the result, because people disinherit their kids all the time. That's not a reason that's not a valid reason to overturn someone's will just because you're upset about it. It generally falls into a couple narrow categories of the person, they're challenging the will because they claim there was some sort of undue influence on the individual. Somebody coerced them into making that change or into signing that will, and therefore it's not valid. Or they did not, or they lacked the capacity, the mental capacity required to sign that will and put it into effect. So there's very narrow reasons why somebody can contest it. Again, it can't just be, well, I'm unhappy that, my brother is getting more than me, or I'm getting, or my brother can't contest it because he was disinherited, right? I mean, there's a lot of reasons that somebody would try to cause a problem, but that they're not actually going to have any legal standing for. So what happens generally, though, when somebody, even if they're successful in proving that, is it will go to either a prior version of the will that couldn't last be proven, when they had signed that proper capacity, or when they had proper capacity, or when they were not being unduly influenced. So if they were still disinherited under that, old will, they might have it yet again, another challenge that they're going to have to overcome. But a lot of times what happens is people, even if they're successful in proving this, and even if that person did not have a prior will, they may still be stuck under, the laws of intestacy, which is, written in the Wisconsin statutes of what happens when somebody does not have any will in place. And it's kind of generally, if it's a first marriage, all the kids are the biological kids of both parents. First it's to the surviving spouse, and then to the children equally is generally, what occurs in those situations. It gets more complex if there's any sort of, second marriage or children from prior relationships, or, things like that. But yeah, so I gave you a very long answer there, but yes, somebody can challenge a will after someone passes. And in fact, that's really when you would challenge it. If somebody is still living, the will has no bearing yet anyway. It doesn't do anything while someone's alive. So the only place to challenge it would really be after someone passed. In theory, you could, the situation in which you might challenge it and when someone's alive, you would maybe more challenge it under like elder abuse or somebody not having the capacity, and that they should have never been signed to begin with. But that would be more of a kind of either a fraud complaint or like an elder abuse complaint than challenging it in probate. But so it's generally after someone passes, first and foremost, that anyone even finds out what's in the will, or more commonly when they actually have the sort of standing to make that complaint. There is generally a time limit to challenges as well. That's another question. The time limit, they'll make notice to all interested parties when somebody files a will. What an interested party generally is anybody that is inheriting under the will, who's listed as a beneficiary, or would inherit under the will, should that will be invalidated. So basically, are they somebody's heir under the law as well? So, if you disinherit a child, you may still have to tell that child at some point that they're disinherited. Once that's all signed off, there's generally a couple months where they can come forward, right? But if they don't by the end of the time limit, or if everyone signs off quickly, they can't come back later, right? Another question I just got is, beyond the will and trusts, are there any other documents required for probate? So required for probate, the only one required, I guess there's really nothing required for probate, because if you have no plan at all, or if you have a will, you're saying I'm intending to use probate. But if the question is more, what's required to, avoid probate, a trust is one way to do that. There's also marital property agreements where you can pass things to a surviving spouse without the use of probate. That's one of the backup tools we often use. There's also something called an agreement to transfer without probate, allowed under the Wisconsin statutes, that you can use to avoid probate. All of these things you want generally together to have a full plan, but in theory, I suppose somebody could use just a marital property agreement to avoid probate, but it's generally not, in my mind, a complete plan. You still would want it with a trust. So you really can't, I hope I'm answering that question the right way. I'm not. So really, if you're intending to go through probate, the one thing I would say is an absolute must is having a will that, maps out your intent. So another question, you mentioned payable on death and transfer on death earlier. Can you help with what that means? A payable on death designation means that account pays out to that individual that you've listed, or individuals that you've listed on that account. Upon receiving a death certificate, that institution will do that. Transfer on death means that account transfers to them, doesn't necessarily liquidate, right? And these are what we call, or commonly referred to together as beneficiary designations. So if you have beneficiaries of a life insurance policy, that's a payable on death beneficiary. The reason that those don't go through probate is because they're essentially sort of contracts that you've signed with the financial institution that says, hey, I'm intending for some amount, or for this amount of money or this account, to pay directly to this person after I've passed. So the probate court has no jurisdiction because of that prior agreement. So yeah, they're designations that you use, that, sort of a listing on an account that, you would submit to the company that holds that account, or to your bank or the life insurance company, or the account holder of your manager of your IRA or 401k. But the reason I don't really view them as estate plans themselves, or as something you want to base your estate plan around, is because, one, it's on every account you own, but two, or that you'd have to update if you ever changed your mind. But two, it's also, it doesn't account for any sort of unforeseen circumstances that might come up, such as an incapacity of somebody, or them passing before you, or a substance abuse issue that they develop at some point that you couldn't foresee. So yeah, to answer your question, they're simply designations you put on an account with the company that owns or holds that account or manages that account for you, that says, upon my passing and proof of my passing, either give the account to these individuals in the percentages or fractions that I've listed, or just pay out to those individuals. So that's how they function generally. Oh, and I realized I went a little over my time here. So if anyone has any other questions that I couldn't get to today, we'd be happy to set aside time to talk to you guys. You can always email learnmore@hooperlawoffice.com, and we will receive that email as well, and hopefully try to answer it in a timely fashion or set aside time to talk. Or if you have any sort of questions that come up and you would like to actually sign up for an initial consultation, please fill out that evaluation form and say that you'd like us to reach out to you. Our initial consultations don't cost you anything. They're free. We usually set aside about 2 hours to have that discussion so that we can really thoroughly work through whatever the concerns are and accurately and adequately give you a good recommendation. So, well, thank you for joining me, and please join us next Wednesday for our talk on the Secure Act and how that impacts retirement accounts.